Hi, this is Josh Blackman. I'm the president of the Harlan Institute, and welcome to the 2025 Harlan Institute Virtual Supreme Court competition. This year, I'm moving the case of Free Speech Coalition versus Paxton. This is match number 7 of the semifinal round, almost halfway done. I can see the light. For petitioners, team 20135, Eileen Wang and Lisa Wang from the Baldwin School in Pennsylvania. And for respondents, teams 20094 from Creekview High School in Texas, we have Lauren Holt and Caroline Reedy. Petitioners begin whenever you're ready.
Mr. Chief Justice, and may it please the court. My name is Eileen Wang, and this is my co-counsel, Lisa Wang, and together we represent the petitioners in this case. So this case challenges Texas House Bill 1181, a law that imposes age verification requirements on websites with over one-third content deemed obscene to minors, and compels those sites to display health warnings. However, the First Amendment prohibits the government from restricting lawful expression and compelling entities to speak against their will. HB 1181 violates both of those principles. Therefore, it must be subject to strict scrutiny.
First, HB 1181 requires adults to provide sensitive information to access protected sexual content, which raises serious privacy and security concerns. In NAACP v. Patterson, the court recognized that just the fear of exposing their sensitive information can chill individuals' willingness to exercise their constitutional rights, and HB 181's requirements create this chilling effect.
Second, in National Institute of Family and Life Advocates v. Becerra, this court made clear that forced disclosures violate the First Amendment. Similarly, in Moody v. NetChoice, the court established that laws compelling platforms to disclose content moderation decisions interfere with editorial discretion and are subject to strict scrutiny. Moreover, the law's compelled warnings stigmatize adult users, suggesting that accessing constitutionally protected sexual material indicates a need for psychiatric help.
Third, HB 1181 constitutes a content-based restriction. In Reed v. Town of Gilbert, this court held that any law distinguishing based on subject matter is inherently content-based and must face strict scrutiny, and HB 1181 clearly falls within this category. Strict scrutiny requires that the law serves a compelling governmental interest, be narrowly tailored to achieve that interest, and use the least restrictive means. While protecting children is a compelling interest, HB 1181 fails on all other accounts.
Moreover, this law is near impossible to enforce because it has no provisions against circumvention methods such as VPNs or the Tor network, and has no control over
international. Can I jump in for a second? So you mentioned a lot of cases. I'm going to ask you about that. You mentioned Reed v. Town of Gilbert. You mentioned NIFLA, Becerra. You mentioned Patterson. You mentioned a lot of the cases. One case I didn't hear about is Ginsburg. So let's just start there. How do you think the Ginsburg case addresses or affects this case?
Well, Your Honor, Ginsburg is inapplicable to this case for a variety of reasons. The most important being that this case centers on burdens placed on adults' access to protected speech, whereas Ginsburg dealt with the state's authority to protect children, which we as the petitioners are not disputing, making Ginsburg inapplicable.
Okay, so just remind me, what were the facts in Ginsburg? Let's just take a step back. What were the facts in Ginsburg?
In Ginsburg, a 16-year-old boy was sold a explicit magazine by Ginsburg without him conducting an age verification on the boy.
Okay. So the clerk in that case was supposed to check the age of everybody, right? People buying the magazines, right?
In traditional brick and mortar stores, the population of people who are prompted for age verification are significantly narrower than it would be online because.
But I asked a question. I only quite answered it. The law in New York required age verification before you sold this magazine, right?
Yes.
Right. Okay. So how is that different than what Texas is doing with its law?
Well, Your Honor, there are several extremely significant differences, which is, again, that it's in person and Texas is online. So the Texas law opens up the door to privacy and security concerns, as every online medium does.
But doesn't the Texas law have things in place to ensure that information is not disclosed and leaked? Isn't that they have to delete the personal data after a certain period of time? Doesn't the law consider that?
Yes, Your Honor. The Texas HB 1181 prohibits websites themselves um, from like using storing the user's information. However, this does not apply to data in transmission, which means that intermediaries are still able to retain this information and potentially use it for different uses. Moreover, there are
I mean, counsel, I know you're all in high school, but there are lots of things you have to do online you need to show ID for. For example, DraftKings, FanDuel's, gambling websites. If all these other websites allow age verification, why is porn different?
um, Your Honor, we believe that porn is a form of artistic expression, and because of that, as established in previous cases as well, artistic speech is constitutionally protected, and adults have the right to access that speech, whereas other forms of content, such as gambling,
You have a
is
constitutional right to look at pornography, but not gamble. Is that what your point?
Um, uh,
Your Honor, we believe that pornography is a form of artistic expression, while gambling is not. So,
What about children? Do children have the right to access pornography?
um, children, well, the Texas law covers all content that is deemed obscene to minors. So according to the variable obscenity doctrine, which the respondents mentioned in their brief, children do not have the right to access the content that the law prohibits. However, that's not the central part of the argument, which was the burden on adults.
Right. No, I know
And
you want to focus on adults, but I want to think about the children for a minute. Um, what is the test for obscenity for children? Maybe you mentioned that a moment ago. What does it mean for obscenity for children?
um, well, Your Honor, in the law, they use the Miller test and then add a phrase with regards to children behind every condition of the Miller test. And it also lists several examples of content that would be deemed obscene to minors. So,
yeah, and adding on to that, while it is deemed harmful to minors, it's still free expression for adults that they are rightfully allowed to access. And by imposing this age verification, it chills adults from accessing this information that they are lawfully allowed to access, regardless of whether, even though it aims to restrict children's access, it does not use least restrictive means to do so. And this is very similar to Ashcroft v. ACLU.
So I've got a question that's kind of on this point of you mentioned earlier that all the parties concede that there's a compelling government interest in protecting children from this content. Can you help me and just brainstorm with me of what could have Texas have done that would have been permissible according to your argument?
well, Your Honor, a less restrictive method that several precedents have recognized before, for example, Ashcroft v. ACLU has recognized that content filtering is both less restrictive and also more efficacious than age verification systems for a variety of reasons. For example, the age verification system does not cover websites that are hosted outside of the US, and it is also prone to circumvention through VPNs, whereas content filtering is not. And there are also several forms of content filtering, such
So
as
I do want to press a little bit on that of I mean it's a tendency that children tend to be more tech savvy and aware of how to navigate and get around these technologies than their parents are. And so I'm worried that maybe these other methods, and maybe Ashcroft was wrong on this point of uh, maybe content moderation isn't enough, and children are going to find ways of getting around that content, or perhaps parents don't know about this technology and aren't able and equipped to provide it for their families.
well, Your Honor, content filtering and moderation is widely used, like for example, in schools, in businesses, in court as well. And again, with circumvention, although yes, kids are more tech savvy nowadays, content filtering is actually less prone to circumvention because you cannot simply download a VPN and get past it, especially if it's device level content filtering. that there's no way for children to get past that, and also ISP level content filtering. So it's restricted by the internet provider. So everyone under the internet service cannot access certain sites. There's no way around that.
Counsel, you just have time to ask one last question. You know what? I'll ask for rebuttal. I'll hold off. Okay. You can wrap up if you like.
Sure. Um,
Um,
so yeah, this law is both massively under inclusive and over inclusive. The 1/3. Oh, thank you, Your Honor.
Thank you.
Yeah.
Thank
We yeah.
you. Your sentence, good.
Uh, the 1/3 threshold is particularly problematic. It's like restricting the sale of alcohol in small convenience stores, but allowing warehouse-sized liquor stores to operate freely simply because the percentage of shelf space dedicated to alcohol is beneath 1/3.
Thank you, Counselor. Okay. All right. Respondents, you have your time whenever you begin. Ready? You can begin.
May it please the court, my name is Lauren Holt, and alongside my co-counsel Caroline Reedy, we represent the respondents on behalf of Ken Paxton and the state of Texas government. We respectfully request a preliminary injunction to have the enforcement of HB 1181, a constitutional regulation protecting minors from obscene material online, grounded in Ginsburg v. New York, and the variable obscenity doctrine. HB 1181 restricts minors' access to harmful content without infringing on adult speech, applying the appropriate rational basis test for commercial regulations. This court has upheld similar protections in Ashcroft v. ACLU 2004 and Sable Communications 1989, recognizing that age verification measures protect minors while preserving adult access. Pacifica 1978 further confirms that content harmful to minors may be regulated in the public's interest.
Just as this court recognized in Wayfair versus South Dakota that technological advancements rendered Quill versus North Dakota obsolete, the same principle applies here, that the internet has transformed to access obscene material, making past precedents like Reno and Ashcroft inadequate to address modern realities. HB 1181 specifically targets commercial distributors of obscene material, entities with lower First Amendment protections as affirmed in Virginia State Board of Pharmacy. Like the restrictions upheld in United States versus Broadcasting, this law ultimately regulates commercial speech for public welfare. Under a facial analysis, HB 1181 remains constitutional, as it has multiple lawful applications and survives a rational basis review. The government has a compelling interest in protecting minors, and this law is narrowly tailored to achieve that goal if this court finds it falls under a heightened scrutiny. We respectfully ask this court to lift the preliminary injunction, and we welcome the court's questions.
Okay. So counsel, let's start with Ginsburg. I asked your friends on their side whether Ginsburg applies. They said it was not applicable. What's your view on Ginsburg?
Your Honor, in today's case, Ginsburg is indeed applicable. While petitioner argues that Ginsburg is not applicable because of its chilling effects and restricts on adults, as was not in Ginsburg, we would like to argue otherwise. While petitioner does argue this sort of chilling effect and that restricts adults' First Amendment protections, of which they have the right to have, because HB 1181 has several civil restrictions on companies retaining such information, it will not cause the sort of chilling effect that petitioners argue. And therefore, Ginsburg doesn't regulate adult speech and is thus applicable in today's case, and allowing for minor speech allowing for obscene material not to be sold to minors.
All right, but your friends on the other side say this is a content-based restriction. How do you respond to that argument?
Your Honor, this can be content-based. We can agree with them, and we can still find that this law should be reviewed under rational basis review.
Hold on, Counselor. If it's content-based, doesn't that mean it's a strict scrutiny test? That seems to be pretty standard here.
No, Your Honor. When it comes to content-based restrictions, if they're restricting speech that is not protected by the First Amendment, such as obscene speech for minors, then such restrictions do not necessarily follow automatically under strict scrutiny, as in Stevens, because Stevens said that not all content-based restrictions need to fall under strict scrutiny.
Remind me, so Stevens was the Crush Films case, right? Where they were stomping on the animals, right?
Yes,
And wasn't that in that case the court declared the law unconstitutional? Didn't the government lose that case?
Your Honor, in that case, they still established, similar to Pacifica, that if we're looking at a content-based restriction, that it doesn't necessarily have to be applied, that it doesn't necessarily have to be reviewed under strict scrutiny if we're having these lawful applications of it, and when we're drawing this distinction between the protected speech for adults versus the unprotected speech for minors.
Oh, I see. So your point is something else, even though it's content based, it involves some other factors might make it less than strict scrutiny. And you think because it's children involved, that's where Ginsburg comes in. Is that your argument?
Yes, Your Honor, that there's this distinction that we should apply Ginsburg here because that allowed for this type of age verification and restriction without unduly burdening adults.
Okay, so then let me ask this follow-up question. Uh, you say this law doesn't burden adults. Your friends on the other side disagree with that. They say that it does burden adults and it creates privacy risks. And also, we can look at the facts on the ground. Because of this Texas law, Pornhub has withdrawn from the market. It doesn't offer services anymore in Texas. So it is affecting adults. So how do you argue this doesn't burden adults when there seems to be that there do seem to be burdens on adults?
Your Honor, it doesn't necessarily burden adult speech by causing this sort of chilling effect, as petitioners argue. Well, of course, Your Honor, as you mentioned, Pornhub may have receded from Texas. That doesn't mean that it's necessarily burdensome on adult speech. It's simply a website not cohering to HB 1181 and thus suffering such consequences. Further, when it comes to such information being retained by these websites, they won't be retaining such information. While petitioners on the other side argue, as such in their oral argument and in their brief, that third parties can sort of retain transmission information, that's not necessarily true because once these third parties act in conjunction with these websites, they're also under such laws as to have such civil penalties if they retain that information. So they won't cause this sort of chilling effect.
But I mean, we all know information is leaked online. No matter what precautions you take, stuff can happen. Um, isn't the chilling effect also that people don't want to be seen as, getting pornography? That, in other words, this might be considered stigmatizing or embarrassing?
Well, Your Honor, our contention is that people will not be necessarily seeing these types of data from adult users. This does not unduly burden the rights of these adults because while the petitioners argue that Ginsburg is inapplicable for this reason, that it burdens the adults unlike there, we can see that in Ginsburg, it did still require an ID verification from some adult users, even if they looked like children.
Further, Your Honor, when it comes to these pornographic websites, many of these pornographic websites already have sort of the security risks and have hackers that are able to trace back to people that are accessing this sort of internet. Instead, what HB 1181 does, it allows for these people accessing that stuff to have more security because it actually instances that if they retain that information, that there will be some kind of penalty in the civil sense. Instead, whereas otherwise, if that information had been retained either by credit cards, as if they were buying something,
So
or
I
by
had a question kind of just on that point, and I'm just kind of spitballing stuff and thinking out loud. What if the burden to access this content was higher? What if an adult in Texas who wanted to access one of these websites, in addition to their driver's license, also had to provide, say, a passport or some sort of retinal scan? Would that be permissible, or does that create a burden that goes too far?
Your Honor, such a burden would be too far, but that is not, and that wouldn't be permissible necessarily, although we would review it on a case-by-case basis. However, specifically here, where it is simply to provide an ID verification as they do at liquor stores or in other things that the state regulates, then it's not that overly burdensome amount.
And furthermore, if I may, Your Honor, there are already cases where we use age verification in the terms of submitting ID on platforms in the United States. One example is Roblox. And in the form of Roblox, they require people to submit a picture of their ID, and they can retain that information in order to access certain live chats. So this country has already established that we can use such means as age verification online in order to protect children from any kinds of harms.
To further that, these pornographic websites are already using age verification for their users, using third parties to verify users' age. Not users, I mean creators, Your Honor. Excuse me, to verify the age of their creators. So if they are able to still use these sort of third parties to verify age of creators credibly, then they could also just institute that for users.
But what about, I get the idea that there's age verification, and then for other things like Roblox, maybe for gambling and DraftKings, that you know that's acceptable. But the Supreme Court has held, for better or worse, that pornographic material is protected by the Constitution. Doesn't the government have to do better when talking about constitutionally protected material, not just, I don't know what the Roblox is, little blocks of people. I don't know. I have no idea what Roblox is, but my kids aren't that old yet. Isn't porn different than Roblox? God, I'm getting myself in trouble.
Yes, yes, Your Honor. It's not petitioner's contention that pornography and Roblox are the same thing. Simply that when it comes to that, some communities are internet websites or apps already use age verification. Actual age verifications is not just a checkbox, but verifying someone's ID to ensure that that platform is safe. That sort of same rationale should apply to pornography. That because if we do it in these circuits where it's so much not as a high risk to children, that when it comes to things like pornography that are such a high risk psychologically to children, that surely the government should be able to regulate it, and that these companies instituting simply a age verification isn't something that is overly burdensome.
Yeah, continue, Counselor.
And furthermore, Your Honors, while the petitioner argues that a more least restrictive means in order to achieve this government interest would be content filtering, we have seen that over the last 20 years, this has not worked. The United States has tried to implement this alternative, and Texas may try to do the same thing, but it ultimately does not work. The reason for this is that filters only work if they are consistently applied. But given the ubiquity of internet-enabled computers, tablets, phones, or watches, even eyeglasses, a consistent application is an impossibility. A single child with an unfiltered device can expose all of his friends to the vilest of obscenity, no matter the 38 no matter content filtering vigilance of our parents.
Good question. Now that I know what Roblox is, don't parents have the role to sort of monitor what their children are seeing? And doesn't this law interfere with the parents' obligation? I mean, for all we know, maybe parents might want their children to see this material. Maybe that's not
Your
a job
Honor,
I agree with, but why is Texas being so paternalistic and getting between parents and their children?
Your Honor, it's our contention that Texas isn't getting between parents and their children. Parents do have the right to raise their children as they see fit. And if a parent sees fit as their child should access any website that is considered to be one-third or more pornographic for any sort of reason, then the parent can go in and provide their ID and provide such information for the child to have access to, something that's not overly burdensome for them to do. The only thing the state of Texas is doing is ensuring children's safety, ensuring that when a parent turns their back and doesn't have access to what their children is seeing. Or as my co-counsel has addressed, when it comes to another child having a phone that hasn't been filtered by their parent, that to ensure that even those times parents can be secure that their children won't be exposed to such harmful material as pornographic material that the HB 1181 seeks to regulate.
All right, thank you, Counselor. You may continue.
And furthermore, we can see very similar restrictions like this internationally and intranationally. In Italy and the UK, there have been many attempts to regulate this kind of content by using ID verification. Italy has a very, very similar law that requires, in order to have children access pornographic or harmful material such as this, there must be an entrance of an ID in order for them to see it.
One second, if I'm still kind of hung up on something the other side was arguing about of this 1/3 content threshold am I understanding correctly that a website that had maybe 25% of their content deemed harmful to minors, that they would be able to not have the same verification process? I guess, how does that play into your analysis? If there's websites that are still able to or children are still able to access that content?
Yes, Your Honor. Well, that plays into our analysis that we are upholding what the law seeks to protect, that it is when it is this 1/3 or more threshold, that's what we're protecting. If it were to be lower than that, as you mentioned, then that would be a little bit harder to restrict. And so, and then we would be drawing kind of where's the line for this arbitrary amount of pornographic material in which we are trying to protect minors from. Here we say that the law correctly finds that it needs to be a 1/3 or more harmful pornographic materials for children in order for it to fall under this bill.
Or I'm just thinking about of what was discussed earlier of companies withdrawing from Texas. Uh, Is it a problem that companies might not know what side of the line they're on? You mentioned it's kind of arbitrary.
Let me clarify, Your Honor. I did not mean that the 1/3 is arbitrary. I meant if we were to go lower than this bar to 25%, that's where we would not be sure on what the line is.
Further, Your Honor, when it comes to these websites, once again, leaving the state of Texas, it's not necessarily something that shows that it's too burdensome or too much for them to decide 1/3 of their material is pornographic. Specifically, as mentioned earlier, Justice Blackman mentioned, when it comes to websites such as Pornhub leaving, or like the big website that left, then those websites are clearly over that 1/3 amount. And simply they just don't want to comply with HB 1181. And that's not Texas's problem. Texas's purpose and interest is in protecting the children in Texas. And that by far surpasses a website just leaving the state.
Good timing. Thank
It
you,
is for these reasons we respectfully request you rule in favor of the respondent. Thank you.
Okay, thank you, Counselor. Okay. 5 minutes for rebuttal. Whenever you're ready, you may begin.
Thank you, Your Honor. So the respondents argued that distributors of sexual content such as porn are offered less protection than artistic or political speech, simply because it is classified as commercial speech. That is not the case. Porn is not considered commercial speech. It is classified as expressive speech unless deemed obscene. Profit motive does not equal commercial speech. And as that is the case, the First Amendment cannot favor certain forms of speech over others, as established in Brown, Reno, and Playboy. Moreover, the respondents also brought up international cases to prove their point, such as Italy. We don't see the value of using foreign law to import into this case because other countries don't have the US Constitution. So we can't use it to prove whether the Texas bill is constitutional or not. And moreover, the respondents argued that 1/3 is arbitrary, or 1/3 is not arbitrary. We strongly disagree with that because take, for example, a small site with over 1/3 content deemed offensive to minors, that site would be restricted. But whereas a really, really large site with, for example, slightly less than 1/3, that is free for minors to use. That is massively under inclusive. It's like
One quick question of maybe I take your point about international law not bearing on our jurisprudence and our approach, but isn't it a concern that states across the nation have passed similar bills of I'm not sure what the current tally is, but I think it could be close to 20 at this point. Of it seems like states are really feeling the need to pass these kinds of laws that content filtering isn't doing that same work.
Mhm. One example of an age verification law was Virginia's age verification statute that went into effect on July, and only one website has complied with that law as of August 15th of that year. And meanwhile, 54 websites have remained entirely unrestricted, meaning which shows that websites do not comply.
Yeah, there are also several examples of this law failing. So yeah.
Yeah. Furthermore, the respondents stated that claim that it's not a content-based restriction because it restricts obscene material for minors, which is not protected. However, this law actually restricts indecent content for adults, which is constitutionally protected. And because it is a content-based restriction, precedents such as Reed v. Town of Gilbert and Playboy established that strict scrutiny must be applied, and not using strict scrutiny overturns many precedents such as Reno, Playboy, Becerra, Reed v. Town of Gilbert, and more.
Find that strict scrutiny is not relevant. If we find that we apply rational basis, do you lose? In other words, can you win under a rational basis standard?
Your Honor, we are not familiar with that. We believe that Uh, it definitely fulfills it is a rationally related, the law is rationally related to the interest that it is created under. However, I think it would still be possible to argue, given so many ways that the law fails to be efficacious and the intense burden that it has on adults, I think it would still be possible to argue that it would fail under rational basis review, although that is less likely.
But so I'd like a yes or no answer to my question, if it's possible. If the court applies rational basis scrutiny, can you win?
Um, Your Honor, we think because the Fifth Circuit has already applied rational basis scrutiny,
No,
we're
I want a yes or no if we can do that. Yes or no. Is it possible for you to win under rational basis scrutiny? Yes or no?
Yes, there is a possibility.
Okay, tell me why. Okay, go ahead.
Well, the law the law is practically impossible to enforce. As again with the VPN issue, uh, 77% of people use VPNs for personal use, and as long as you have VPNs, there's no way this Texas law can do anything about your access to all of these sites. And also, apparently, searches for VPNs rose by almost like 1,500% after this law was introduced. So we can clearly see that happening in the future.
Okay. All right, may wrap up. We have 20 seconds left.
Okay. One other thing that respondents mentioned was the case Pacifica. We believe that that is inapplicable because Pacifica deals with radio, which is a uniquely pervasive medium, whereas the internet is not intrusive. There is unlikely for minors to have accidental exposure to such content. Thank you, Your Honor.
All right, very good. All right, excellent. Thank you both so much. Both teams come back on the camera. Um, I know that was hard. And the fact that I'm pushing you as hard as I was um, reflects the fact that you can handle it, and you can. I treat you, the four of you, four very bright young students, the same way I would treat law students. There's no difference in the sort of questions I would ask. And I think that you all rose to the occasion. A couple things that I really liked is you have a very strong command of the case law, which is not easy. I can tell you read lots of cases. You understand what the various tests are, you understand what the various standards are, and you're able to articulate answers. And not just your prepared remarks. I think your prepared remarks were very strong. I think you're able to articulate answers sort of in response to what we were asking. Um, Not always as responsive as maybe we want, and we can work on that, but you at least had in mind how to answer our questions. I think the sort of room to grow, and there's always room to grow, is that when you're answering a question, this is going to be hard, but just bear with me for a minute. Your answer should always begin, yes, Your Honor, or no, Your Honor. It's tough. In fact, with the petitioners, I was even saying, come on, yes or no, give me an answer, right? And that's important because I want to have a clear answer. Maybe the answer is you have to win under strict scrutiny, under a rational basis. Maybe you can't win, whatever the answer is, right? But you have to give a clear answer because then I can sort of know what direction you're going in. Um, Now we say yes, Your Honor, no, Your Honor. You go yes, Your Honor, but, or no, Your Honor, but. You can pivot. Say, can you win under rational basis scrutiny? Yes, Your Honor, but, or no, Your Honor, we can't win, but we think that's the wrong standard. And that's fine. We have to at least answer the question squarely. And sometimes being candid with the court has a lot of value, a lot of benefit. Another thing to sort of think about is when a judge starts talking, you have to stop immediately. It's very hard to do that because your instinct is just keep talking, you have all this other thing to say. But once a judge starts talking, you ready to move on to the next point, and whatever you're trying to say almost doesn't even matter anymore. And you have to sort of just stop and listen. And that's sort of hard to do on Zoom, especially because there's like a bit of a delay. But a a lot of moot court competitions are on Zoom now. That's been the trend in recent years since the pandemic. So I think you have to sort of think about how to um, work. Uh, when the judge asks a question and you sense that the judge is satisfied with your answer, you have to then transition back to what you were talking about. You have to pivot back. And that transition is actually very hard because you're so worked up with the question, you probably forgot what you were even saying before. You have to find a way to bring your discussion back to the topic at hand, and that's not easy. I think you all did well on that. In terms of just sort of items sort of improve on substantively, um, I think you all let off with your strengths, whichever cases you're strongest on, but you can also use your opening statement to address your opponent's strengths. So, for example, when the respondents go first, I don't think you mentioned, maybe I don't remember, I don't know if you mentioned Ginsburg in your opening, but you knew I was going to ask you about Ginsburg, right? That's the leading precedent that the petitioners have. And you could say, my friends on the other side say Ginsburg is appropriate or Ginsburg is not appropriate. Here's why it is. In other words, you don't have to wait for me to ask the most likely question. And if you volunteer, it's like, oh wow, they anticipate my question. That's good. And same thing for petitioners. When I asked you at Ginsburg, you seemed a little bit flustered, just a little bit by it. Um, and that should have been part of your opening presentation, why Ginsburg um, was not relevant. And this is just sort of like next level stuff. This is like what I would tell a third year law student to do. I'm telling a bunch of, what are you guys, juniors, seniors in high school, right? Talking about your juniors and seniors to do this. This is well beyond your years, but I'm giving you this advice because I think you can handle it. No, I don't think, I know you can handle it because you're there. Trust me, every round, every match, I'm not giving this kind of advice for the students. I'm giving you kind of next level advice. 'Cause I think you can handle it. Because I think you're both sort of like right on the doorstep of like really turning it on. Um, you're both both teams are very confident. Confidence is not something you can teach. You have to have confidence inside of you. It's hard to teach confidence. You're all very confident. You're calm. You didn't get flustered a little bit here and there, but you didn't get too flustered too bad. I didn't get the sense that you were nervous, and if you were, you fooled me because I didn't sense nerves. I get nervous when I argue a case, but you didn't seem nervous. You have clear diction. You have clear pacing. You don't have issues where you're running too fast like I do, or jumbling your words. I didn't hear like filler words but I didn't. Maybe Robbie heard it. I didn't hear those words. I thought you were very careful. I think these are both two strong teams. And also, I think among the four of you, the partners were matched pretty evenly, which doesn't always happen. I think Elise, Eileen, and Lauren and Caroline, you're both, you're about the same level. I didn't get the sense that one partner was dominating more time than the other, which happens a lot, and that's the frustrating thing. Hey, let your other partner talk. I always kind of nudge them. It doesn't always work well. You also had a good rapport. Handing off was very natural. So this was both, I think, a good round. I gave you my constructive feedback. I think all of you did quite well. And Robbie, anything you want to add to this?
Nothing too much to add, but I was just really impressed with how well both teams responded to each other. I thought uh you were listening, and I thought that was really impressive of thinking quickly on your feet and able to come up with arguments. I got the sense that y'all listened to the actual oral arguments. If I'm mistaken, then you were just very well prepared. Um, that was just really, really good.
All right. Anything that you want to ask us?
I was wondering, uh, which which side do you think is gonna win for this case?
Oh, I don't know, Robbie. What do you think? You're. I'll let you go first.
That's really dangerous. He's a professor and I'm just a student, but I've been reading a little bit about it and listening to the oral arguments. It's going to be a closer call, in my opinion, than I would have thought when I just first read about the case. I do think that the Texas law, I do think that the Supreme Court is going to instruct that something higher than rational basis is applied.
Okay, thank you.
Yeah, I don't, I do a lot of Supreme Court prediction. I'm not sure about this case. Again, I think Robbie is right. This is closer than I thought it might have been. And what often happens at the Supreme Court is they start discussing a case, and then someone starts writing the opinion, and they realize it won't write. And what does that mean? They thought it would come together, and it doesn't come together. I think you have these two lines of precedence. You have the Ginsburg line of precedent with the rational basis, and you have the Reno Playboy line of precedent with strict scrutiny. You have the rights of the children, and I'm sorry, you have the rights of the adults, and also you have the security of the children, the safety of the children. Those are not easy cases to reconcile. And then you have Brown versus EMA, which was a case from about 10 years ago, that upheld a state law that restricted sale of violent video games to minors. On its face, it was a 7-2 case. Only Thomas and Breyer were in dissent. But Roberts and Alito were concurring mostly in judgment. And Kagan has actually said since this was the hardest case she had in the court. So I don't know if Brown comes out the same way it does today as it did 2000, was it 10 or so, 15 years ago. I think the courts sort of peaked on free speech in 2011 with Stevens, the Crush film case. I think it's been since then they've been trending downwards, and this might be a case where they start saying, well, maybe we've gone too far with this free speech stuff. But I don't know. I don't know, but your guess is as good as mine.
We were also wondering what moot court competitions are like, maybe in universities and college.
Law school.
Law
This.
school, like this.
This.
Yeah.
You.
Really?
I treat you no different than a law school moot court competition. I have you write the brief. I give you an argument. I give you 10 or 15 minutes a pop, and I ask you lots of questions. That's what moot courts. Robbie, you're second year law student. Am I exaggerating?
Not at all. Like a couple hours from now, I'm going to meet with my moot court team, and we're going to be doing the same thing of asking each other pretty similar questions. I mean, the topic is different. I think when you get to college and law school, hopefully for all of you, I hope to see that for y'all. The topics tend to be a little bit more diverse and a little bit more specialized. Of the thing I'm dealing with right now is this niche restitution issue, but the degree of intensity of questions is very, very similar.
Thank you. Thank you.
What other questions do you have?
No, I think we're good, at least.
Okay. Well, that's all I got. I will turn the recording off. I wish you all both the best of luck. And if you're ever in Houston, welcome come visit my class anytime.
Thank you.
Thank you.
Thank you.
Bye.
You're in Texas, you're closer. Pennsylvania's a little bit further. But
Yeah, only like 3 hours.
Yeah.
everyone, bye-bye.